the issue of diversity in American law schools and how universities have managed it and how the American Supreme Court has dealt with it. The students in their feedback were amazed at how the issue of equality, which is a universal value, is being dealt with in legal education and legal transactions through legal institutions very differently to be able to reach the same goal. I think that this feedback has revealed something more to me in restructuring the social relevance of legal education. Ladies and gentlemen, if law and legal education has to be retained as a public good, which I believe it is, if it wants to receive the people's support for law schools, we need to reorient our priorities in developing the curriculum, keeping the focus on justice. It is good that I find the word justice education. If legal education could transform into justice education, if people can come as the focus of all our educational activities, I believe that it will retain the popular support, legal education will get the public support, and the curriculum and the pedagogy will accordingly regain, its importance in this regard. Naturally, we have to go beyond the cognitive level of learning to the affective and emotional domain. How do we relate it? Very challenging job, and that's what we are going to hear from our fellow panelists. This is a short experience of my 60 years career as a law teacher. Thank you.
Distinguished guests, ladies and gentlemen, good morning. You don't sound happy to be in Pune. Good morning, ladies and gentlemen. Thank you. My name is Lithopa George Mpedi. I'm Executive Dean at the Faculty of Law of the University of Johannesburg, and I'm also the President of the South African Law Deans Association. On the program, I'm supposed to be the second speaker, so I thought I'll see how the first speaker performs and adapt, but now I'm the first. Well, following the brief provided to me, I chose student mobility as a component of globalizing legal education. And as per the brief, one had to speak to the challenges, strategy adopted, and lessons learned. Before I talk about the strategy adopted, and I was told I have strictly 10 minutes or less, so I'll try to be within the allotted time. Before I talk about our experience as regards student mobility, I need to clarify the fact that in this case, student mobility includes inbound and outbound movement of students. And it comprises of structured and unstructured learning. And of course, the benefits of such an approach are well known, as we have already heard this morning. You could include some of the following as benefits that one could really draw or derive from this student mobility. And this include, students changing their outlook towards life, changing perceptions. In Africa, some of students from other countries get shocked to learn that Africa is not one country through these processes. It provides an opportunity for students to learn about other legal systems. And of course, we shouldn't forget the lifelong friendships that develop from these exchanges. As a strategy that we adopted to ensure that our students can go abroad and we can welcome students, we relied mainly on cooperation agreement. I listened earlier on when it was indicated that 14 cooperation agreements were created through the IALS. We are busy catching up. So far, we managed only 4, but counting. And every meeting is an opportunity to create such opportunities for our students. Of course, in these agreements, key issues have been covered, have been used. Student and staff exchanges, extremely important. Study abroad programs, some short, hosting summer or winter schools play an important role, moot courts, and of course joint academic programs, which are really slow. And within our context, the challenge is that at an undergraduate level is difficult. It's mainly at the postgraduate level due to some of the regulatory requirements that focus on the local situation. The challenges that one face as part of this exercise is that in most instances from where we are, there's a mismatch between the academic years. Our academic years are mainly misaligned. If you look at South Africa, our academic year starts in January, ends in December, and elsewhere it starts in August and ends, you know, I don't know, July the next year or something like that. So it's really problematic if you are to have students who come for one module or two. Another challenge, at least from our side, sending students abroad, is funding, which we are dealing with through other creative means, which I'll share with you. And another thing that one would raise as a challenge is the general bias towards the north, which is something that, in my opinion, has to be changed. When people talk about student mobility, they think, you know, we have to send students to the north, from Africa, from Asia, from Latin America. And the question I ask is, this should be sort of a balanced thing. We also wish to welcome more of students from the north. There's a lot to learn in the global south. And the other thing that I think needs to be addressed, which I see as a challenge, and it pains me, is a situation where you get people going mainly to the north to learn about Africa. You know, I'll give you an example of African Oriental Studies, instead of learning at the source. Of course, we need to have this everywhere, but it will help if this is also spread, going to the source. Lessons learned from our experiences is that in terms of funding, you know, there's limited funding available for mobility, but if one is creative through summer programs, winter schools, one could generate a little bit of revenue to support this kind of programs. Short learning programs are also important. The so-called continuing legal education programs for professionals also play an important role. One could use proceeds from that, as we are doing, so that our students can go and learn elsewhere, and then we can also host students from peer institutions. Another lesson learned is that we need to ensure that the curricula of modules within the academic program you know, have learning content that takes into account the global dimensions of legal education. We have to have programs that would be attractive also for international students. If you have programs elsewhere, they must speak partly to the issues that the students have to, you know, their contexts, to make them meaningful. And this is mainly possible at postgraduate level, that is master's level in many institutions. Another lesson learned is that developing and implementing joint academic programs takes time, so one needs to really be patient, because you need to comply with institutional and other regulatory policies and frameworks. So this must be complied with to make sure that everything done in a proper way. Another lesson learned is that we must never exclude neighboring countries from wherever we are. This is what we have learned. We'd be quick to fly to you know, to the north and everywhere, and ignore our local neighbors, you know. And this, to correct this, my university, the Faculty of Law is part of that. We started a program a few weeks ago called Southern Africa by Bus, where our students who travel by bus, is not that expensive, to neighboring countries, interact with students. Lecturers also interact with students in classroom. You know, that will be structured and also unstructured. Hopefully in the future I'll be able to report how this goes. And of course, this is also important, especially if there are plans, you know, to regionalize, you know, to develop regional integration. This is a way to drive that. Another important point, which is my last point, is to say to you, ladies and gentlemen, we really need to encourage South-South cooperation in our endeavors to drive student mobility. There is a lot to learn from the South. Thank you very much for your attention.
Well, thank you very much. My name is George Williams from the University of New South Wales in Sydney. It's a pleasure to be here with my colleague Gabrielle Appleby, and we've come a long way, and we greatly appreciate the hospitality of our hosts and the opportunity to meet many of you people today. having come a long way away, I thought I'd quickly put up a slide to give you a sense of exactly where I have come from, to give you a different sense of where you can locate a law school. While we're waiting for that, I'll get into my presentation. Where my challenge that I'm examining is one of technology, and as a new dean, as someone who's got a lot to learn from the people of this room, I began as a dean last year essentially by listening. I made appointments with not only people in Australia, not only firms in Australia, but in the United Kingdom, Hong Kong, United States, in fact around the world, including major firms, businesses that are very heavily engaged in business in India, in China and elsewhere. And I see now I've got the slide up just to give you a sense of where we're based. That is Coogee Beach in Sydney, just around the corner from the famous Bondi Beach. The University of New South Wales Faculty of Law is just tucked up behind Coogee Beach, and I invite you to visit us at some point. We actually tend to put visitors up right at the beach, about 50 metres from the sand, and what is a really beautiful place in Australia. So I began by listening, and I listened to about 60 different organisations to ask them what should legal education be like in the 21st century. And what I found in those conversations is that one topic came up without exception, and that was technology. In every single conversation, the firms were either excited or concerned about the opportunities or challenges that they saw would affect what graduates will be doing over the next few years. What they described is an enormous process of disruption. In fact, the largest changes we are likely to see in the practice of law in our lifetimes, and perhaps even the greatest transformation in legal practice in more than a century. This is something that has already begun. It's very uncertain as to how far it will go. But to give you a sense of some of the things that we need to face as educators, these include the fact that many firms expect that they will greatly reduce the number of law students that they will employ over the coming years. Particularly the big multinationals, KPMG and others. Some are projecting a drop as much as 50% of the number of graduates they may take. KPMG in particular has been designing what it sees as the law firm of the future, and it believes that in about 10 years, a law firm today that has 2,000 lawyers working for it could do the same work with 30 lawyers working for it. Given the processes of automation, particularly around tax, multilateral investment, arbitration and the like, they're projecting an entirely different model by which lawyers will do business. And of course this may come as a shock, but it shouldn't, given the disruption we've already seen in other professions. Think of how retail has changed over recent years, banking, journalism. Whole industries are changing, some in fact are almost disappearing. And what we're going to see in law is this disruption, but also enormous opportunities that also will emerge for globalised law firms and also legal educators. In Australia, we're already seeing whole new jobs emerging. Some firms are now advertising not for lawyers, but for techno-legals, as they call them. They're looking for a new breed of law student who can blend technology, coding and the like to do a set of tasks that did not exist even last year in some of these firms. Elsewhere, we're seeing massive new dispute resolution systems arising. eBay, for example, you may realise that resolves over 60 million disputes annually without the involvement of a human being. Humans designed the systems, but that's 60 million disputes that might have involved a lawyer, and now they need not a single lawyer to actually get to an answer. We're also seeing a lot of new AI systems emerging as well. Within Australia, there's one called ALIRA, which is being developed to give tax advice, and it has all of the tax statutes, all of the legislation, and a very sophisticated interface to answer questions. And at one law school, a student who had no knowledge of tax law, had done no study whatsoever, in fact they weren't even a law student, sat a sophisticated tax exam. And they sat that exam using the ALIRA system to ask questions about the exam paper before them. And that student with no knowledge got a distinction in that course. Again, demonstrating that with the benefit of some of these systems, a person with no training, but only the ability to interface with the system, may in fact be able to outperform a number of lawyers. So what can we do as educators? How do we face what is an enormous challenge and enormous opportunity? And I know that in many law schools you're already seeing change. At my own, we're now introducing courses where students can design apps and often these are dedicated to the justice part of the law and justice. So for example, at our law school, apps are being designed to assist people who are dealing with the problem of domestic violence. An app that explains what the law is, where to go for help, what the person's rights are, and how to deal with that in an immediate sense, in a way that the person would never have necessarily had legal advice for, but with the benefit of an app, we can actually provide access to justice in a way that never would have been possible for many people. My own view, though, is that when it comes to how we do respond, we need to respond early. It's an area that a wait-and-see approach is dangerous and potentially counterproductive. You only have to look at other industries, retail and the like, to see how slow adopters have been badly affected by changes in technology, and in fact how law schools here can and may find their own business models under threat in the longer term. New entrants, MOOCs as they're called, the multi-online platforms, or educators that are not connected with universities or law schools may seek to enter this place to provide new training. We also need to recognise that the challenges here are very, very difficult for us to meet. There's enormous uncertainties about what will happen, and also a significant lag in our own training of our graduates and the situation they will face. To take our example, we've just admitted our 2017 intake. They will be in legal practice in about 2023. Now, I have no idea what the technology will be like in 5 or 6 years. It's changing so rapidly. So how do we train law students to deal with a world that doesn't yet exist, to be competitive for jobs that have not yet been created, and how do we design that as educators to give them the best education, the best opportunity, and in doing so to not miss out on the key ethical and justice components that must determine what is a good law degree. So to give you a quick snapshot of how we're trying to respond at the University of New South Wales, the 5-point plan that we've got, and it's an evolving plan. The first is we're driving big changes to our curriculum. We're introducing things like blockchain within our contracts course. We're also introducing mandatory familiarity to coding and other forms of technological literacy. We need legal graduates who have a level of digital literacy that they have never before had with us. We don't need students who can code, they don't need to be programmers, but they do need to work with expert technological systems. Particularly in large global law firms, it won't be long before every single person in those firms must work alongside at least one AI system. And in doing so, they need to understand those systems, not to be passive, but to actually interrogate them, to use them in ways that avoid the biases and problems that naturally come with those systems. The second thing is to embrace new innovations in teaching. And of course here there are great opportunities on a global scale to reach out, to connect our students to each other's in ways that has not been possible. To look at new partnerships, to look at new technologies in the classroom, the flipped classroom and other aspects that you'll be familiar with. The third thing we're doing is shifting increasingly from knowledge transmission as educators to fostering the right skills. We're recognising that we don't have the knowledge now to prepare people for the jobs that they will have in a couple of years. What our students will need, though, is a base level of information plus skills around resilience, flexibility, adaptability that will go with digital literacy to give them the best opportunities. We need to recognise that the lawyer of the future will likely have multiple careers, not just a legal career, and in fact those careers will be greatly affected by technology and other change. The fourth thing we need is we've got to educate our students about the big changes that are coming in the job market. We're encouraging our students to move away from combined degrees of commerce and law to increasingly do combined degrees of computer science and law or artificial intelligence and law. We're saying that's where some of the best and most interesting jobs will be of the future. And it may increasingly be in the field of science and law that we see some of the best options for law graduates. And the fifth and final point I wanted to make is that as educational institutions we need to do more to cooperate, to consolidate, to coordinate our research activities when it comes to technology and the law. At the University of New South Wales, we're about to announce a new industry-funded law and technology hub that will be a base to reach out to other global law schools to see how we can work together to form a vision of how legal education should operate in the 21st century in light of these challenges. So that's the challenges we see it. That's our response to this to date. It's one that's changing rapidly as it must. It needs to be flexible, but it's one very much that we look forward to talking to you more about. Thank you.
Good morning, my name is Giuseppe Nessi. I am from Trento, Italy. I'm the Dean of the Law School there and the Vice President of the National Law Society in Italy today. I must say that George said many things I was going to say, because I must say that surely he said everything much better than what I can do. Our greatest challenge, but I will be very brief, so I will try to touch on some points. Our main challenge in recent years have been innovation. We try, on the one side, to adapt to the new challenges coming from society. On the other side, we are trying also to keep the tradition, because if I may add something to what George has said, we think that law schools should not run towards the request by the market, as Professor Menon has said. We should try also, we should try to keep, of course, into account, to consider what is going on in the world. At the same time, we have to stick to our principles, to our tradition, and also to our values that are at the heart of legal education, even in a world that is changing every day. So, however, what we are trying to do in order to meet the request for innovation is to first of all, adapt our courses to the new requests. This does not mean, in our opinion, always to introduce new courses, but this could mean to teach in a way that takes into account the novelties coming from society. First. Second, this means also that the ways of teaching could be improved, could be surely be sensitive to what happens in the world, and the same happens with the collaboration with other universities and law schools. When we have negotiations towards agreements with other law schools, we always take into account their framework, their features, and we try to give them some advices and to keep some advices from what they do. So this mutual exchange, in our opinion, is crucial in order to understand what's going on and to adapt ourselves, but also to contribute to the improvement of other law schools. The same thing happens with, as regards the collaboration with other departments. We are a law school, but we are very open to collaboration with the Department of Economics, with the Department of Medicines. And this is why our law school has improved a lot in recent years in law and technologies, as well as in law and bioethics. At the same time, of course, we think that we have also to be very, very keen not to lose what we have reached until now. And for us, for instance, something that is in our DNA is comparative studies, which means not only law comparative studies, but also comparative studies in other fields. And so, just to say by way of conclusion, I'll say that the lessons we've learned in recent years is that we have to take into account innovation, but without losing sight of our tradition. But we will discuss it surely during these days. Thank you very much.
Good morning. My name is Louis Franceschi. I'm French by descent, Venezuelan by birth, Kenyan by choice, and now Indian by heart. Now, I'm the Dean of Strathmore Law School in Nairobi. I was reluctant to stand here because a lawyer with a microphone and a willing audience is a very dangerous person. But I will summarize very quickly. Law schools, to my mind, and I hope I will see this in my lifetime, are going to disappear in the way we know it. The world is moving in a direction that we lawyers are not suspecting will succeed, but it will, interdisciplinary. For example, I see what's happening or going to happen, and it's something we are trying to push in Kenya, but the regulatory bodies are still in the 20th century. That is, a student will not register as a law student at Strathmore University, but as a student. And if the requirements are harmonized, then this student chooses one subject from this career, another one from here, another one from here. When he meets a threshold, he gets the law degree. He keeps going a little bit, and maybe he gets an IT degree or a commerce degree. This could happen. It's already happening in certain places in the US, for example, when you see people getting double or triple degrees. What is important, and we can't lose, is the ability of lawyers to think like lawyers, critical thinkers. But certainly, a lawyer who knows accounts and who knows IT is an incredible tool in the market. And that is what the new law firms, because law firms will also disappear as we know them. KPMG, for example, in East Africa, they are becoming a law firm with accountancy firm, consulting firm, the whole thing in one package, which is one-stop shop. And this is bound to happen. And then what we are trying to do to catch up with that momentum is, for example, opening the curriculum, the elective subjects, for the students to choose any elective from any school, provided the timetables match. So instead of offering elective, because we lawyers are very clustered, so we say, well, the elective is banking law or insurance law. You say, no, the elective, choose anything from engineering, from chemistry, humanities, whatever you want, and enrich yourself in the area where you think you will add value when you practice. This is interesting. However, the points I had told Barbara I could focus on to bring this home. In the Singapore Declaration and the Madrid Protocol, there were certain three key issues that were mentioned. And I remember in 2013, when we were discussing these documents, a very experienced professor said, but come on, this is common sense. And someone else who was 20 years older than him said, my friend, common sense nowadays is the most uncommon thing. And these 3 points are infrastructure, faculty, and values. And I mentioned this to the chair of the panel that because they have an amazing relationship. Infrastructure. Well, if the place, the environment for the students and the lecturers is not conducive, we will not produce the quality because we are not preaching with deeds. So if the universities, and this happens a lot in our third world countries, are dirty, neglected, if the lights are not working, if the bulbs are hanging, if the doors don't